Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoyed this legal education content, and today is the day I earned that subscription. For today's story, we are dealing with the U.S. Department of Justice, which has issued a response in Donald Trump's request for the appointment of a special master. As you will recall, the Department of Justice searched Mar-a-Lago and took many documents. Donald Trump argued that some of these documents were protected by presidential privilege. Now, it's not even clear to my mind that he can invoke that privilege because it belongs to the office of the president, and he's not the president anymore. It was privileged and remains privileged by the office of the president. So it's not clear to any extent that he himself can invoke it. Of course, also there might be attorney-client privilege, documents that relate to his personal capacity, in which case those documents, of course, he could argue that they are privileged. Either way, he wanted a special master to be appointed, which would be an independent referee. Okay, it's someone independent of the Department of Justice, independent of the president, who would be in a position to review these documents and to review whether or not they're privileged or not. And this request is not, on its surface, invalid. The appointment of a special master to look over potentially privileged documents is something that often happens when sources are seized that are privileged. So you'll see these, for example, most frequently if an attorney's office is searched and seized, because there's a lot of information there that's privileged to a lot of potential people. And so you need a special master to review whether or not other people's privileges are at stake. Someone other than the law enforcement themselves would probably be the most common situation you would see that. So it's not something you see a lot. It's not frequent, but then again, it's not unheard of. And here, of course, there are potential issues in play. Now, what made Trump's request a little bit abnormal was the timing, right? Normally, a request for a special master is something you file basically immediately. When the attorney's office is searched and seized, and a whole bunch of documents are taken, which might be protected by a whole bunch of clients, you file a motion that day or first thing the next morning. Trump took weeks to file his. And the Department of Justice has said, at least in part, that they have already reviewed everything, so that Trump's request, if it ever had validity, is moot, because there's nothing for a special master to do. But that's not necessarily the only thing that they said, right? They gave some more things. And these things that they've given in response to this request have exposed further problems for President Trump in terms of his potential legal liability. So Trump's case, or the case against Trump, in other words, is more defined. And we're in a better position than we were to analyze potential legal liabilities. So we're going to go ahead and do that. We're going to review this document in its full and try to see what it does say, what it doesn't say, what questions it leaves, what defenses it leaves, what problems it might have. Just do all the law education stuff. So let's go address this document, which was filed by the United States government in the case of Donald Trump versus the United States government. This was the lawsuit that Donald Trump filed in response to the search asking for the appointment of the special master, in which, incidentally, the judge had previously indicated that they were inclined to potentially grant the request. So the Department of Justice, of course, brought its game. So let's go ahead and go see this and see what it has to say. So this is the United States' response for the motion for judicial oversight, namely by appointment of this independent referee, the special master, and for additional relief. On August the 22nd, 2022, 14 days after the Department of Justice executed a search warrant, right away, that's a problem. Again, this is normally when you're doing this, you're doing it immediately. 14 days is kind of late. So 14 days after doing this search, the plaintiff filed a motion for judicial oversight and other relief. A little late there, Chief. In his motion, plaintiff requested, among other things, the court appoint a special master and the government return to the plaintiff certain property. The following day, the court ordered plaintiff to file a supplement to a motion addressing certain questions. On August the 26th, plaintiff filed the supplement, and on August the 27th, the court entered a preliminary order on the plaintiff's motion. In compliance with this order, the government hereby files its public response to plaintiff's motion. So the court said, I'd like to hear your argument on this, government. And the government's like, well, we're all too happy to bring our argument into it and tell you why this is dumb on any number of levels. So let's do that. The legal issues presented and requested relief in the filings are narrow, notwithstanding the wide-ranging, meritless accusations levied against the government in the motion. So there are a fair number of accusations, but they're speculative, but they're not, I wouldn't say, meritless. Right? The concerns are potentially real. They're necessarily speculative because you don't know what they're going to do or what they're not going to do. But that doesn't make them meritless. But whatever. Plaintiff's filings present 3 items. Whether plaintiff is currently entitled to return of any property, to injunctive relief, and to the appointment of a special master. Okay. Do you want, and that also actually, I don't even think that Donald Trump actually asked for injunctive relief. I guess they're assuming it. Is there a footnote on this? They also wanted a more detailed search warrant. The government filed a more detailed receipt. So there is a more detailed receipt that's been filed under seal. So whatever. All right, because I don't think Donald Trump actually asked for an injunction. I guess the injunction was implied. Plaintiff's motion to appoint a special master, enjoin further review of the seized materials. Well, I guess there was an injunction in that respect, I suppose. And require the return of seized item fails for multiple independent reasons. As an initial matter, the former president lacks standing to seek judicial relief or oversight as to presidential records because the records do not belong to him. Yeah, this is a fundamental problem, right? Whose privilege is it? Whose privilege is it? Right? So to the extent it covers presidential records, then it's not his privilege. But then again, whether or not they are presidential records is a matter that maybe only the president can decide. And maybe did decide. And there's some case law on this point relating to Bill Clinton with presidential records. Please note my vocabulary carefully. I say presidential records, not governmental records. Right? So, can he relay issues on presidential records? Well, whether or not they are presidential records might be something he had the sole ability to determine. And maybe did determine. All right, anyways. The Presidential Record Act makes clear the United States has complete ownership, possession, and control of them. Yes, but what they are is something that the president appears to have unilateral ability to declare as to presidential records. Furthermore, this court lacks jurisdiction to adjudicate plaintiff's Fourth Amendment challenge to the validity of search warrant and his argument for returning or suppressing materials. Really? You lack jurisdiction? Okay, let's give that a shot. I suppose the Fourth Amendment concerns are in the nature of the criminal case because the Fourth Amendment is in that remedy. So maybe the argument is the other court has jurisdiction as to that respect? Okay. For these reasons and other, plaintiffs has shown no basis for the court to grant the injunctive relief. Plaintiff is not likely to succeed. He'll suffer no injury absent injunction, let alone irreparable injury. And the harms to the government and public would far outweigh the plaintiff. Okay? Even if this court had a jurisdiction to entertain the claims, appointment of a special master is unnecessary and would significantly harm important governmental interests, including national security interests. Appointment of a special master is disfavored in a case such as this. In any event, the government's filter team has already completed its work of segregating any seized material that are potentially subject to attorney-client privilege. Please take note here, attorney-client privilege, not presidential privilege, which are definitely two distinct things. And the government's investigation team has already reviewed all the remaining materials, including any that are potentially subject to claims of executive privilege. So, again, the request is arguably moot. Appointment of a special master to review materials potentially subject to claims of executive privilege would be particularly inappropriate because binding Supreme Court precedent forecloses plaintiff's argument that review of the materials be personally within the executive branch raises any such privilege concern. Furthermore, appointment of a special master would impede the government's ongoing criminal investigations, and if the special master were tasked with reviewing classified documents, would impede the intelligence community from conducting its ongoing review of national security risk of improper storage of these documents. Okay, fair enough. Okay. And from identifying means to rectify or mitigate any damage the improper storage might cause. I'm not sure there was any really damage caused by the improper storage. That itself doesn't make it okay. But they are physical records in physical boxes in a property protected by the Secret Service. So they're not computer files that can be just hacked into. You'd have to get physical access to them, which, is somewhat difficult. So I'm not sure there was any exposure from storage. That itself doesn't make it okay. I'm just saying that there probably isn't much damage from this, because you'd have to, physically be there. And the Secret Service would probably have words about that. Yeah, anyways. Lastly, the case does not involve any of the type of circumstances that have warranted appointment of a special master to review materials, potentially subject to attorney-client privilege. Again, not presidential privilege, attorney-client privilege. Those are two distinct things. Mindful of the court's ruling on the present motion, is not the same court that's authorized the search warrant from which the civil action results. The government provides a below detailed recitation of facts, many of which are provided to correct the incomplete and inaccurate narrative set forth in plaintiff's filing. So yeah, to be fair, Donald Trump definitely had his own narrative of this, his own story of this. And he, his story is one story, but the U.S. government might have a different story. All right, so let's recite the U.S. government story on this thing. Okay, the National Archives, upon observing it was missing presidential records from the former president's administration, attempted to obtain the missing records voluntarily. Again, I think this is a misstatement and a misstep from the U.S. government. The problem is, as presidential records, as distinct from governmental records, which are two distinct categories, I'm going to keep mentioning it because it's an important distinction. As it relates to presidential records, there is no criminal enforcement mechanism. You can't get a search warrant to go searching for presidential records, because even if they are presidential records, which the president alone has the ability to determine whether or not they are, as to presidential records, because the Court of Appeals for the D.C. Circuit said so, as it related to Bill Clinton, right? But even assuming they are presidential records, there's no criminal enforcement mechanism. So you can't get a search warrant for the records because there's no criminal enforcement mechanism. And so I think this is a mistake, because I think it ultimately muddles the legal issue, right? Because now you run into this problem down the road, or potential problem down the road, about why did we get the search warrant? What is the nature of the search warrant, right? It's hard to come up with a good example that explains the problem. But it would be like the government obtaining a warrant for two things, one of which is blatantly illegal and one of which is blatantly legal, right? Even by the government's own admissions. So I don't know what the right analogy would be, but it would be a little bit like getting a search warrant where the government wants to search your house for, I don't know, your own short stories that you've been writing, as well as the cocaine. Those two things are kind of distinct in a lot of ways. This like the short stories you've been writing are a little bit distinct from the cocaine, one of which is legal, one of which is illegal. And so then you run into this problem, even if they find the cocaine, you run into this problem of like, wait, why did you mention the short stories you've been writing? This reminds me of an old Mitch Hedberg joke, one of my favorite comedians. He says, in order to do this stand-up special, I had to take a medical exam, and I don't like the medical exams because they ask a bunch of confusing questions. Like, have you ever tried sugar or PCP? This is the nature of the problem. It's like one of these things is very different from the other thing. They don't really belong in the same breath. So, yeah. there's some issues here. Anyways, Andrew Hansen says that comparison has me snorting with laughter. I'm glad. I try to pay the sugar. I try to pay off the sugar masters. Right? It's like, yeah, okay. It's a little bit weird. Anyway, so them mentioning the presidential record thing, I think is a mistake. I think it's a mistake in the search warrant application. I think it's a mistake here. It's like, let's just focus on the things that are blatantly illegal and not muddle the issue with things that are not, or at least that don't have criminal enforcement mechanisms. Throughout 2021, the United States National Archives and Record Administration had ongoing communication with representatives of former President Trump in which he sought to transfer of what perceived were missing records from the administration. Okay. And apparently there's a letter that's attached, and we'll read that letter, so we'll skip it for now. When producing 15 boxes of documents, the former president never asserted executive privilege over any of the documents, nor claimed any of the documents in the boxes containing classified markings had been declassified. Well, I mean, he's not necessarily required to make those claims, because he can make those claims later. But, okay. National Archives asked representatives of the former president, as required by the President's Records Act, continue to search for any additional presidential records that had not been transferred to NARA. Thank you very much to NYRENALMD. Thank you for becoming a new YouTube member. It's appreciated. Okay. Well, can I do this? Make that margin go away too? Cool. Tiffany Burner gives $4.99 in Mitch Hedberg voice. I used to steal documents. I still do, but I used to too. Appreciate it. Yeah, Mitch Hedberg is one of my favorite comedians. Rest in peace, Mitch. Observing that the 15 boxes contained highly classified records, National Archives sent a referral to the Department of Justice. Okay. In its initial review of material within the boxes, National Archives identified documents marked as classified national security information, up to level of top secret, which is the highest, and including sensitive compartmentalized information and special access materials. That's, kind of concerning. Them being marked that way isn't the same thing as them being that way. But, it's at least prima facie, right? Like, whether or not they are classified is something we'll have to get into down the pipe, right? But the documents are marked classified. And there's no marking saying they're not classified. And so the law, at least as to that much, is pretty clear, right? If you have documents that are marked classified, they have to be treated as classified because they might be classified, right? And so if you are the government, and assuming you have search warrant to search the property in the first place, so assuming you have the basis to go look for the thing, when you find the thing and it's marked classified, you can presume it's classified. Now, Donald Trump may or may not have declassified it, but on the prima facie standard, which literally means on its face, that's what prima facie means. Prima facie just means on its face. On its face, what does it say? Well, on its face, it literally says classified. So on its face, classified. And you might have to get into whether or not it is or is not classified because, as we've discussed before, the president has unilateral authority to declassify. Now, and he doesn't necessarily have to follow any special procedures to do that, right? The law, including executive orders, specify procedures, but of course, that doesn't necessarily end the analysis because what beats an executive order and what beats a statute, right? And the answer is the Constitution, right? And so to the extent the president has constitutionally derived power Nothing else other than a constitutional amendment could take it away, right? That would be the nature of something being in the Constitution, right? So all the statutes in the world and all the executive orders in the world can't strip the president of whatever inherent constitutional power he has to classify and declassify. And he doesn't have to necessarily follow any mechanisms to classify or declassify. But there is, of course, one interesting caveat about that. Because the interesting caveat, of course, becomes how do you prove it? Right? Because again, the documents are marked classified. So let's assume that Donald Trump declassified it. Well, how can you prove it? Well, you could prove it through a written memorandum. You could prove it through maybe some oral statement he made. Someone could testify to that. You could prove it through some sort of directive that someone overheard. So you could prove it that way. But it has been suggested that the president can just declassify it in his own mind without telling anyone. Now, this strikes me as a bit of an unlikely proposition. He can just mentally say to himself internally, it's declassified, and without any external indication of any kind, which is the premise, he can declassify. This seems odd. This seems like an odd conclusion. But even if it is true that the president can just mentally in his own head say, like to himself, silently, these are declassified, and assuming that that is legally operative, well, how would you go about proving that at trial? And there's only one possible way, right? There's only one possible way. If you assume, for the sake of argument, the president can mentally, himself, to himself, without telling anyone, to declassify, that it is declassified internally to himself, like, well, how can you prove that at trial? There's only one way. And that would be President Trump would have to testify, because he would be the only person in this scenario that could have any knowledge of his own internal mental state, right? We're not looking at this point to something externally he did. It's not he told someone. It's not he wrote a document. It's not he marked the thing. It's not that he did this, right? In this scenario, it's just in his own private head, in the recesses of his own mind, he did this. Well, how do you know whether or not that happened or not? Well, you'd have to get him on the stand and he'd have to testify, right? Because I mean, only he can testify as to what his own internal thoughts are. And then, of course, whether or not a jury believes that is a question of fact, because a jury would have to conclude whether or not, in fact, at the time, while he was president, when he still had power, whether or not a jury would have to conclude at the time whether or not he internally, in his own mind, without any external indications of any variety, to himself said these were declassified, which means that President Trump has to testify. It also means that President Trump would also be eligible for cross-examination, which would yield the most intense cross-examination in the history of time, if that ever comes to pass. So we're a lot of steps away from that happening. But I'm just saying, if this comes down to an argument that President Trump, while president, mind you, it had to be while president, internally, in his own mind, without any external indication, just simply wished it into declassification status, and we have to get President Trump on the stand, which incidentally, of course, him taking the stand means what? He waives his Fifth Amendment protection, right? You have the right not to testify against yourself, but now you're the only one who can testify because you're the only one that has the information, which means you have to take the stand, which means you waive your Fifth Amendment protection, which is leading to probably the most hilarious cross-examinations of all time. So something to look forward to in the long, long distant future. Yeah. Who has the burden of proof? The accused or the accuser in this case? The government always has the burden of proof. The government always has the burden of proof. The problem in this scenario is the government has everything it needs because it has the prima facie case. Right? The government can make its prima facie case. The government's prima facie case is, well, the documents marked classified, the executive order and various statutes say that to declassify you have to follow these mechanisms. Those weren't done. So, yeah. So the problem is the government can make its prima facie case. So the government can make its burden of proof. If President Trump wants to come back and say, no, actually I declassified them, now he's offering an affirmative defense, which the government still has to disprove. The thing is that he's the only one that can offer any evidence as to that, because if the claim is, well, I did it in my own mind, the government has a right to cross-examine that. Because credibility is a question for the jury. So, it's yielding all fun times. Can the president pardon himself? Yes. While he was president, he can. In my opinion, yes, the president can in fact pardon himself, but he would have had to have actually done that. And also, his ability to pardon himself isn't prospective. Like all ability to pardon, it is reactive, right? So the president can, at least in my humble opinion, the president can pardon anyone, including himself, for all crimes committed up to that point, right? The president can't pardon. It doesn't matter whether or not you've been charged, right? You don't have to have been convicted. You don't have to have been charged. You don't have to have been investigated. You don't have to have been arrested, right? But the crime has to have actually occurred, at least theoretically, right? Because just because you accept a pardon, at least in my view, doesn't mean that there was guilt. There's some language to the Supreme Court that seems to suggest the opposite, but let's move past that, right? But the crime, or not, has to have actually occurred. You can't pardon someone for something they're going to do in the future. So sure, President Trump had the ability to pardon himself for any crime, assuming he did, which again, you'd have to have some evidence for. But President Trump's ability to pardon himself would only be for any crimes that occurred on or before January the 20th of 2021 at noon. At 12:01 p.m. on January the 20th, 2021, President Trump's pardon power turned into a pumpkin, and pumpkins are less persuasive when it comes to judicial effect. So his power to pardon himself can't extend to anything that happened past that point. So that's not really going to work for possession of governmental records at this point. There's some problems. There's some problems. Ian Kensel gives $5, says, what you're saying about President Trump declassifying in his mind reminds me of Trump saying his net worth fluctuating depending on how he's feeling that day. Yeah, there's some problems. There are some problems in the future, to be sure. $5 from Kiwi, New York Upstate. I saw a Japanese prima facie movie once. Law is interesting. I don't think the Japanese prima facie movie is the same prima facie that I'm talking about. But the First Amendment protects all kinds of speech. So enjoy your Japanese movies. I'm sure you do. Fun and exciting. Let's press on. Sandra C. says, is it true that classification is a moot point under 18 U.S.C. 793? Yes. And to my knowledge, he hasn't been charged at least, or they haven't said that they're investigating anything with respect to classification, right? So whether they're classified or not doesn't necessarily end the analysis, which is why I made a point of saying there's a difference between presidential records and governmental records, right? So whether they're classified or not is not the same thing as saying whether they're governmental records or not. So yeah. Have I heard of some executive order coming into effect in 2022? I don't follow all the executive orders, so I'm not sure exactly which one you are referring to. But thank you for your question anyway. Is there not a rebuttable presumption that if you can do something legally, you did do it legally? Trump declassified the documents so he could legally possess them. Well, no. I don't think the way you're asking the question. The question isn't necessarily did he do it legally. The question is did he do it at all? Right? So the question isn't did he declassify the documents legally. The first question is did he declassify at all? And if there's no memos, if there's no writings, if there's nothing orally, right? Then how the problem isn't whether Trump has the ability to declassify. The problem is did he? And it's like, well, how do you know? Right? So it's like, is there a presumption that if you can do something legally, if you did the thing, you did it legally? Maybe. But then, of course, you have to prove that he actually did it. Right? It's like, yeah, that's more the problem. Uncivil. He was possessing the documents unsecured. He could do that legally if he declassified them. It's only illegal if he didn't. I disagree. Classification is part of the problem. It is not the end of the problem, right? Whether the documents are classified or not triggers one aspect of the statutes, right? Basically, the Espionage Act. The Espionage Act is the thing that's going to be triggered by the possession of classified documents, right? So if you take away the classification issue from the legal analysis, then basically you wipe the Espionage Act off the list of possibilities. So you can just strike out Espionage Act. Okay, so that's no longer a thing. How about Presidential Records Act? Well, as I said, there's no criminal enforcement mechanism. So you can strike out Presidential Records Act, right? But how about some other statutes? Well, there are statutes dealing with concealment, obstruction, possession of just government documents, whether they're classified or not. And if you do it with an aim of obstruction of justice, which is a whole other thing, right? So if by merely having the documents, that's one level. By doing it with the intent to obstruct, that's 20 years. Even if they're not classified. So whether or not they're classified gets you the Espionage Act concerns. It doesn't answer all your concerns. So I respectfully disagree. Isn't criminality in the Espionage Act required to be improved of intent? Yes. You do have to prove intent in the Espionage Act, as you do for most crimes, right? But if we so yes, among other things, you would have to not only prove that they're classified, you have to prove intent, which maybe Trump can get past, to be quite honest, because it's unlikely. For example, he packed up his own boxes and didn't necessarily himself look through them. So can he, assuming that they are classified, does that necessarily mean he's guilty of the Espionage Act? No, it doesn't. Right? So even if they are classified, it doesn't mean that he's guilty either. Yes, you'd still have to prove intent. Trump can maybe get past the issue of intent. So it's not necessarily clear that if they are classified, he's guilty. But if they're not classified, well, we can move past the Espionage Act completely and move on to other issues. Dougie Fresh gives $5. It says, Kash Patel on Trump's legal already publicly stated he witnessed Trump declassify and will testify. So what now? Well, those are evidentiary issues. Those are evidentiary issues for the future. And we're not prejudging this, right? The documents themselves are marked classified, right? The law is pretty clear on this point that because they're marked classified, they have to be treated as classified. That doesn't mean that they are classified, just that they have to be treated that way, right? So it may very well be the case, and I'm not prejudging it. It may very well be the case that if we're concerned about the Espionage Act, which is not the extent of Trump's problems, but if we're concerned about the Espionage Act, and if someone is willing to testify that he saw Trump declassify them, and that person is believable, and credibility is a question for the jury, right? So a jury will have to determine whether or not that person's telling the truth or not in the absence of any written document. But I witnessed President Trump, sprinkle the magic water, as it were. Okay, well now it's a question for the jury about whether you believe that person or not. But that's an evidentiary question way down the road about whether or not you believe that happened or not. And so what now, DOJ? Well, DOJ has the prima facie case. DOJ has the prima facie case. They got it set. They've got it sold. They've got the documents. They're marked classified. They've got their prima facie case. So they've met their burden. And all you have left is, well, okay, do you have someone who's believable or not to knock the burden backwards? But I think the DOJ has their prima facie case. So why is the presumption the U.S. government has standing to even look for these records? Do you mean that the way you asked the question? I'll answer it both ways. Why do they have standing to look for the records? Because they're governmental records and they belong to them. That's their standing. If your question is why do they have probable cause to look for the records, because why do they think they are? Well, that portion of the document was redacted and we don't know. So I'll answer it both ways. Question. Why did Hillary Clinton not get the same treatment? Having all the classified documents on her computer at home, she wasn't even present. Well, okay, we can go through that at least a little bit. Hillary Clinton's exposure was for the, let me see if I get this right, it's been a little bit. It was for the, there's a law that requires business of the government to be in writing, and there were some problems there because she was using personal email accounts. And there was also the possession of classified material. The issue in question, there was multiple issues in question, relating to intent, relating to the number of documents, which were relatively minor in the grand scheme. Also, the statute in question, at least on its surface, didn't state a mental state requirement. It read as a strict liability crime, but that is a disfavored reading. So there was a legal problem on what is the right legal standard here, because the statute didn't provide one, but you tend to read against strict liability. It's a very disfavored interpretation. So there were some legal problems in terms of that. Her intent, assuming it was required at all, was a little unclear as based on her actions. And the statute that she would have had the strongest liability under hadn't been used in a prosecution in something like 80 years or 100 years. And so the problem was, even assuming she was guilty, which was not at all certain, it would look very, very political to charge her because no one is ever charged with that particular crime. So the crime in question had some legal problems with its definitions, which created issues. And it hadn't really ever been used. And using it on her had some obvious political overtones. And so that was what was going on there. But it's been a hot minute since I considered all those issues. And I don't remember, but I don't believe it's been a hot minute, but I don't think Hillary Clinton had any special access program records on her server. Not that, at least that I remember being shown, but it's been a hot minute. Okay, let's press back into the documents. In its initial review of materials within the boxes, National Archives identified items marked as classified national security information up to the top level of top secret and including sensitive compartmentalized information and special access program materials. NARA informed the Department of Justice about that discovery. Specifically, on February the 9th of 2022, the special agent in charge of the Inspector General sent a referral via email to the Department of Justice. The National Archives stated that a preliminary review of 15 boxes indicated that they contained newspapers, magazines, print news articles, photos, miscellaneous printouts, notes, presidential correspondence, personal and post-presidential records, and a lot of classified records. Of most significant concern was that the highly classified records were unfolded, intermixed with other records, and otherwise improperly identified. The NARA referral was made on two bases: evidence that the classified records had been stored at the premises up until mid-January 2022, which okay, and evidence that certain pages of presidential records had been torn up. Whether or not they're presidential records, though, is not at all clear. And they might have been stored there, but how do you know they're still stored there is the problem that we don't yet know. Based on the second concern, NAR indicated citation to some section. As the NAR referral stated, the 15 boxes contained highly classified records. Upon learning this, the Department of Justice sought access to 15 boxes in part so that the Federal Bureau of Investigation and others in the intelligence community could examine them. The Department of Justice followed the steps outlined in the Presidential Records Act to obtain the 15 boxes. On April 12th of 2022, the National Archives advised counsel for the former president that he intended to provide the FBI with records the following week. That access was not provided then because a representative of the former president requested an extension of production deadline. As the acting archivist recounted, on April 29th, the Department of Justice advised counsel to the former president as follows. Okay, so Department of Justice apparently is writing a letter in April to Trump saying this. There are important national security interests in the FBI and others in the intelligence community getting access to the materials. According to the National Archives, among the materials in the boxes are over 100 documents with classification markings comprising more than 700 pages. Some include the highest levels of classification, including special asterisk program material. Access to materials is not only necessary for purposes of ongoing criminal investigation, but the executive branch must also consider an assessment of potential damage resulting from the apparent manner in which these materials were stored and transported and take any necessary remedial steps. Accordingly, we're seeking immediate access to these materials so as to facilitate necessary assessment that needs to be conducted within the executive branch. $10 from intellectual iconoclasm, thank you. Clinton had top secret SCI on her system, and after they found it, it was penetrated. As a former InfoSec guy and system admin, I can assure you she committed treason with malice. Well, as a person who's an InfoSec guy, you should well know that treason as a crime is defined specifically in the Constitution. So I'd like you to show me where she admitted in open court or two witnesses can verify that she gave aid and comfort to a declared enemy of the United States. So let me know about all that. Because, by the way, that's required, right, for treason, as long as we're being specific, right? All the physical documents in the world won't let you convict of treason because treason, according to the Constitution, requires either open admission in court, mind you, in court, or two eyewitnesses. So all the server logs in the world, you're going to have a little trouble with the treason with malice. But what do I know? I'm just reading the Constitution. Let's press on. On the same day, the Department of Justice sent this correspondence. Counsel for the former president requested that an active extension before the materials were provided to the FBI and stated that in the event of another extension not being granted, the letter should be construed as a protective assessment of executive privilege made by counsel for the former president. In response, National Archives rejected both of counsel's requests. First, National Archives noted The significant time, 4 weeks, has elapsed since the National Archives first informed counsel of intent to provide documents to the FBI. Benghazi should cover the treason charge. No. Pressing on. Accordingly, the National Archives informed counsel it will provide the FBI access to records beginning as early as Thursday, May the 12th, 2022. Although the former president could have taken legal action prior to May the 12th to attempt to block the FBI access to documents in the 15 boxes, he did not do so. Yeah. Between May the 16th and 18th of 2022, after finally providing access to the 15 boxes, the FBI agents conducted a preliminary review of documents and identified documents with classification markings in 14 of the 15 boxes. A preliminary review revealed the following: 184 unique documents bearing classification markings, including 67 documents marked as confidential, 92 documents marked as secret, and 25 documents marked as top secret. Further, FBI officials observed markings reflecting the documents were subject to sensitive compartmentalization and dissemination controls used to restrict access to materials in the interest of national security. Throughout the investigation, the FBI developed evidence indicating that even after the 15 boxes were provided to NARA, dozens of additional boxes remained at the premises that were also likely to contain classified information. Now, this is the thing I wish I had more information on. What was your basis for that? This was the entire section that was redacted, right? He sent us 15 boxes, 14 boxes of which contained classified information. Okay, but how do you know that there's still classified information at Mar-a-Lago, which is the only reason you can go search for it, right? You have to go, if you're going to go search his house for documents, why do you think he still has documents? He sent you documents. Why do you think he still has them? This is the part of the search, this was the part of the affidavit that was very, very redacted and annoying. Accordingly, the Department of Justice obtained a grand jury subpoena for which the President's Counsel accepted service on May the 11th. The subpoena was directed to the custodian of records for the office of Donald Trump and requested any and all documents or writings in custody or control of Donald Trump or the office of Donald Trump bearing classification markings. The Department of Justice also sent the former counsel a letter suggesting they could comply by providing any responsive document to the FBI at the place of their location and providing from the custodian a sworn certification the documents requested represent all responsive records. The letter further stated that if no responsive document existed, the custodian could provide a sworn certificate to that effect. The subpoena's return date was March 24th. Counsel sought an extension for complying. After initially denying the request, the government offered counsel an extension for complying until June 7th. Counsel for the former president contacted DOJ on the evening of the 2nd and requested FBI agents meet him the following day to pick up responsive documents. Which, sounds like he's complying, to be honest. I mean, if he has until the 7th to respond and he's on the 2nd, it's like, come pick up your documents. I mean, it sounds responsive. On June the 3rd of 2022, 3 FBI agents and a DOJ attorney arrived at the premises to accept receipt of the materials. In addition to counsel for the former president, another individual was also present as the custodian of records for the former president's post-presidential office. When producing the documents, neither counsel nor the custodian asserted that the former president had declassified the documents. They don't necessarily need to. Or assert any claim of executive privilege. That part is a little bit more suspect. Instead, counsel handed them in a manner that suggested counsel believed all the documents were classified. The production included a single red well envelope, double wrapped in tape, containing the documents. I don't know what a red weld envelope is, but I'm intrigued. The individual present as custodian of records produced and provide a signed certification letter, which provided in part the following. Based upon information that's been provided by me, I am authorized to certify on behalf of the office of Donald Trump the following. A diligent search was conducted of the boxes that were moved from the White House to Florida. This search was conducted after receipt of the subpoena in order to locate any and all documents that are responsive to the subpoena. Any and all responsive documents accompany the certificate, and no copy, written notation, or reproduction of any kind was retained to any responsive document, and swearing to the following. So it sounds like the president is complying at this point, so what's going on here? A Redwell envelope is basically an accordion folder. Thank you. I appreciate that information. After producing the Redwell, counsel for former president represented that all the records had come from the White House were stored in one location, a storage room at the premises, and boxes of records in the storage room were the remaining repository of records from the White House. Counsel further represented there were no other records stored in any private office space or other location at the premises, and all the available boxes had been searched. As the former president's filing indicates, the FBI and DOJ were permitted to visit the storage room. That sounds like a mistake, but, okay. I mean, letting the FBI into your home, man, Vampires and police. Don't invite either one into your home, really. Anyways, carrying on. Critically, however, the former president's counsel expressly prohibited government personnel from opening or looking inside any boxes that remained in the storage room, giving no opportunity for government to confirm that no documents with classification markings remained. Yeah, but that's not enough. You can't confirm it, but how do you know that there are documents there? Especially in view of an affidavit that says there's nothing here. So it isn't that you saw any documents, apparently. So what's going on? Once in a secure government setting, the FBI conducted a preliminary review of the documents contained in the Redwell envelope. The preliminary document review revealed the following. 38 unique documents, $2 from Cherry Ann Mex. Wild, it had been illegal to copy post-precedent. Oh, sure, maybe. Yeah, it might very well be illegal to make copies. Quite possibly. I mean, there's a whole host of legal issues that are in play here, which are not resolved on their ultimate legal merits, but it's possible, sure. The preliminary review revealed the following. 38 unique documents bearing classification markings, including 5 documents marked as confidential, 16 documents marked as secret, and 17 documents marked as top secret. Further, the FBI agents observed markings reflecting sensitive compartments and dissemination. Counsel for the former president offered no explanation as to why boxes, government records, including 38 documents with classification markings, remained at the premises for nearly 5 months after the production of the 15 boxes, nearly 1.5 years after the administration. Okay, I mean, yeah, but, all right. Isn't it illegal to photograph classified materials even in their folders? No. No. No, that's fine. The cover sheet is not itself classified. So, yeah, it doesn't violate the Espionage Act to take a photograph of the documents with the cover intact. The cover itself is not classified because that wouldn't make any sense. Because a person has to be able to look at the cover in order to read it to determine it contains classified information. If the cover were itself classified, you couldn't read it in order to read that it says classified information. And we don't live, fortunately, too much in the Kafka trap. So is it illegal to take a photograph of classified documents with the cover intact? No, that's fine. Because you don't see what's inside it. Yeah, but thank you for your question. Anyways. Through further investigation, the FBI uncovered multiple sources of evidence indicating the response to the May 11th grand jury subpoena was incomplete, and classified documents remained at the premises, notwithstanding the sworn certificate made to the government on June the 3rd. Okay, I'd be interested to know what that is. In particular, the government developed evidence that a search limited to the storage room would not uncover all classified documents in the premises. It sounds like you have an insider or something. I'd be interested to know what that is. The government also developed evidence the government records were likely concealed and removed from the storage room, and that efforts were likely taken to obstruct the government's investigation. This included evidence indicating the boxes formerly in the storage room were not returned prior to counsel's review. Against that backdrop and relying on probable cause, the investigation had developed at that time. On August the 5th, the government applied to the magistrate judge Reinhardt for search and seizure warrant, which cited 3 statutes: willful retention of national defense information, concealment or removal of governmental records, and obstruction of federal investigations. On the same day, Reinhardt found probable cause existed that evidence of the crimes will be found on the premises and authorized a search warrant. Based on the search warrant, the government was permitted to search the 45 office, which is the former president's office space at the premises. He is allowed an office that the government pays for. As one of the perks of being president, you get an office paid for by the government for life, so nice. All storage rooms and all other offices or rooms with the premises that are used by the president and his staff in which boxes could be stored, including all structures or buildings on the estate, but not areas currently, that is at the time of search, occupied, rented, or used by third parties, and not otherwise available to be used by the president and staff. Judge Reinhardt authorized the government to seize any evidence of the applicable crimes. Importantly, the government was authorized by the warrant to seize any physical documents with classification markings, along with any containers or boxes in which they're located, as well as other containers, boxes that are stored or found together with them, and any government or presidential records created during the former administration. Please note here, the government itself notes the distinction between governmental records and presidential records. Those are definitely 2 distinct categories. The president probably has unilateral authority to determine what are and are not presidential records, but not unilateral authority to determine what are or are not governmental records. So, yeah. Pursuant to the above protocols, the government seized 33 items of evidence, mostly boxes, falling within the scope of Attachment B to the search warrant, because they contained documents with classification markings or what otherwise appeared to be governmental records. 3 classified documents that were not within boxes, but rather located within desks of the 45 office were also seized. Per the search warrant protocols described above, the seized documents include documents that were collectively stored or found together with documents with classification markings. The investigative team has reviewed all the materials in the containers that the privileged team did not segregate as potentially attorney-client privileged. Please take note again here, not presidential privilege, merely attorney-client privilege. Of these seized evidence, 13 boxes or containers contain documents with classification markings, and in all, over 100 unique documents with classification markings, that is, more than twice the amount produced on on June 3rd, in response to the grand jury subpoena, were seized. Certain of the documents had colored covered sheets indicating classification status. That is very typical. These classification levels range from confidential to top secret, and certain documents include additional sensitive compartmentalization that signify limited distribution. In some instances, even the FBI counterintelligence personnel and DOJ attorneys conducting review required additional clearances before they were able to permit the review. So yeah, the people who seized the documents didn't initially have clearance to review them and had to get special clearance. Okay, Cherry and Max gives $5. Thank you very much for all your generous super chats, by the way, Cherry. Learning not to depend on my initial thoughts and probably a dumb question. But if this was done purposefully and nefariously, what reason would that be? If what was done purposefully and nefariously? Do you mean the president? I don't know. I don't know what his motivations would be. I'm not sure he necessarily has motivations beyond whatever his naked, immediate self-interest seems to be. The President Trump, has been described by some as being an egomaniac, but I think that's an incorrect description because I don't think the president has ego at all. I think the man is just pure, unadulterated id. And I think that his presidency and his behavior is best described by pure, unadulterated id. So I'm not sure that he has motives or necessarily the ability to form motives, because that would require something else, and it's a little bit, it's a thing. It's a thing. Where was I? Share, document, window, DOJ. Okay, back to this. Okay. Let's see. Notwithstanding counsel's representation on June the 3rd, 2022, that materials from the White House were only located in the storage room, classified documents were found in both the storage room and in the former president's office. Just got here, how screwed is Trump? Well, the government's case looks better is about the best we can say. There's a lot of legal questions yet to be resolved. If this thing is going to a trial, the legal questions are real. The legal questions are very real. And I would imagine we're looking at the possibility of things being up and down from the Court of Appeals a couple times in relation to this. Like normally, of course, in a criminal trial, you don't normally go to appeal for issues. Normally you go to the trial all the way through and then go to appeal, of course, and you don't do the interlocutory thing. But here, these are presenting some threshold legal questions that are quite novel and important to resolve. So if this thing winds up in a court someday, I think we're going to be up and down between the trial court and the Court of Appeals several times. We'll probably spend 2 years, 3 years, or more before just trying to get the preliminaries resolved on some of this stuff, because it's just a nightmare. And Cherry says, can Trump run if this happens? Yes, he most certainly can. He most certainly can. The Constitution itself sets out the requirements to run for president. There is a case called Term Limits versus Thornton at the U.S. Supreme Court, which, as the name implies, dealt with term limits for Congress, but nevertheless said that you can't add to the requirements or subtract from the requirements to be a member of the Congress. And if you can't do it for a member of Congress, you can't do it for the president. And President Trump meets all the required criteria to run for president. He's over the age of 35. He was naturally born U.S. citizen. He has lived in the United States for at least 14 years. And that's it. Those are all the requirements. So I can run for president. Trump can run for president. If Trump is sent to trial, even if he's convicted, he can run for president. I know some of the statutes say that you can be disqualified from holding office. I do not think that those are constitutional with respect to running for president for the reasons I just said. So, yeah, because you can't add to or subtract from the requirements. So, Trump could be tried and convicted and run and win and then pardon himself because these are all federal, which is hilarious or disturbing depending on who you ask. But yeah, there's a lot of game left to be played here, one way or another, for sure. And we're not worried about state prison, Eledian, because these are charges from the U.S. government in federal court. And what would happen if a president won who was in state court or being held by state prison? I don't know. Maybe, hopefully we'll never have to figure that out. Hopefully we'll never have to figure that out. Okay, anyways, carrying back to the document at hand. Notwithstanding counsel's representation on June the 3rd, the materials from the White House were only located in the storage room. Classified documents were found in both the storage room and the former president's office. Moreover, the search cast serious doubt on the claim in the certification, and now in the motion, that there had been a diligent search for records responsive to the grand jury subpoena. I mean, that's fair, to be sure. In a storage room, the FBI agents found 76 documents bearing classification markings. All the classified documents seized in the August 8th search have been segregated from the rest of the seized documents and are being separately maintained and stored in accordance with appropriate procedures for handling and storing of classified information. That the FBI, in a matter of hours, recovered twice as many documents with classification markings as the diligent search the former president's counsel and other representatives had weeks to perform calls into serious question representations made by the certification and cast doubt on the extent of cooperation. I mean, that's not an invalid point, to be sure. The privileged team has completed its review of materials in its custody and control that were identified as potentially privileged. The privileged review team identified only a limited subset of potentially attorney-client privileged documents. Pursuant to court order, the privileged team is permitted to do a whole bunch of things. $1.99 from Tread. I'm still watching, but chat sniping is too much. Is chat sniping something I'm doing? I don't know if that's something I'm doing. Am I chat sniping? Or are you referring to things the chat is doing? I'm confused. I respond to chats from time to time with my thoughts, unfiltered as they are. I'm confused. Pressing on. So the privilege review team did a whole bunch of things related to that. Not you? Oh, okay. Good. I was confused. Plaintiff also asked for a special master and related relief in anticipation of moving for return of property. As asserted, the requested relief is necessary to ensure that movement can properly evaluate and avail himself of important protections of Rule 41, particularly the ability to move for return of seized property. But in order for an owner of property to invoke Rule 41, he must show that he has possessory interest in the material. That's, true, among other things. Plaintiff has no property interest in any presidential records, but whether or not they're presidential records is another problem, including classified records seized from the premises. The Presidential Records Act provides, under a heading entitled Ownership of Presidential Records, the United States shall reserve and retain complete ownership, possession, and control of presidential records. But of course, there is that case from from D.C. Circuit that says the president gets to decide what are presidential records. So they're kind of chasing their own tail on that one, to be honest. And presidential records include any documentary material that created or received by the president's immediate staff, or unit or individual of the executive office, whose function is to advise or assist the president. There's some case law that seems to suggest some things to the contrary. Neither of plaintiff's filings addresses or even cites the statutory provision. That's pretty sloppy. Nor does plaintiff offer any other colorable argument that he has a property interest in any presidential record seized. Plaintiff's motion, in fact, asserts the documents seized at Mar-a-Lago on August the 8th were created during his term of president. That doesn't necessarily mean they're presidential records for the reasons we've described. Because they don't belong to plaintiff, Rule 41 gives him no special rights. I'm not sure about that. Isaac Bowles gives $5, says, dumb question. Is it even possible he's not the subject of this investigation, and instead it's someone in his immediate circle? Sure, absolutely. That's possible, right? It is, just because you are searched doesn't necessarily mean you are the target of the investigation, right? It just means that you have evidence in your possession, which, suggests that you're affiliated in some sense because you're in possession, right? It's like, well, how is it that you have no exposure and you're also in possession of this material? But it could happen. And even if you have criminal exposure, it doesn't necessarily mean that you're the target of the investigation, nor that the government necessarily has an interest in you, right? It just so happens that you have the your exposure doesn't necessarily mean they're after you. So sure, is it possible they're after people other than the president, or in combination with the president, or otherwise? Sure, it could mean a whole bunch of things, right? That President Trump has the material doesn't necessarily mean that we're targeting him, and it certainly doesn't necessarily mean that he has criminal liability, because there are some unique questions when it comes to the president because of the Constitution, as we've tried to highlight to some degree, right? So there's a whole bunch, because it's President Trump, and this would be true obviously for President Clinton or President Bush or anyone, all right? Because it's the president, we have a whole other set of questions, because now we have a new source of authority that we wouldn't normally bring into the picture, which is the Constitution, right? So yeah, there's many questions. John F. Face gives $4.99. Is this a case of Trump seizing original documents rather than copies, preventing them from being preserved? I don't know. If they are originals with no copies, then that increases Trump's exposure dramatically. Right? Because if they're merely copies, right? If they're merely copies, then like the government hasn't in some sense been deprived of anything. If these are originals with no copies, then we're in a different situation. And we're not in a position to analyze that question right now. And that Trump has materials, that are governmental in nature, there's a whole host of problems. So, there's a whole host of problems. And the government may not necessarily know either, as has been suggested. The government may not know either. That's part of what investigations are for. And as long as they have probable cause to believe that Trump's home has documents that are marked classified or appear to be governmental records, right? Because on a probable cause standard for a search, that's what you're looking for, right? You have to have probable cause to believe he has documents marked classified or appear to be governmental records or seem to be in the ownership and possessory control of the United States, right? Because probable cause is not a certainty. It's like 30%. And exactly where you are in terms of the percentages is debatable, right? So 30% is just a number I picked out of the air, right? It's because what's probable cause, you're going to get a whole bunch of answers, including from me, incidentally. Ask me a different day, you'll get a different answer. But 30% is probably about what we're talking about. Maybe 20, 25, something like that, right? So how much confidence do we have to have at this stage of the proceedings? About 20%, 25%, 30%, something like that. Right. This is also the nature of the criminal justice system in general, which is also a nice little point we can talk about. Okay. In criminal justice, right, as cases move forward, the probability of the certainty escalates, right? The certainty goes up and up and up, right? So the ultimate question, of course, is proof beyond a reasonable doubt, right? That's the ultimate question a jury has to reach someday, is proof beyond a reasonable doubt. Now, what proof beyond a reasonable doubt is, again, doesn't have a definition. So, but if you ask attorneys, you're typically going to get an answer above 95%, right? So it's 95%, maybe it's 99%, maybe it's something else in that ballpark, right? That's the ballpark you're talking about. How much confidence do you need to have to convict? Let's say 97%, right? But that's way at the end, right? That's way at the end, after we've had all the presentation of evidence and all the witnesses and all the testimony, right? That's how much confidence we need at that stage of the proceedings. Do we need that stage at that level of confidence earlier on? Hell no, right? And you can see you can see at stages of the proceedings, as things go on and on and on, your level of confidence has to increase. So if you're a police officer, like how much confidence do you need to have to start an investigation? right? Do you need probable cause to start an investigation? Hell no. Like, how much do you need? Well, there's some vague evidence of some variety of something. So how much confidence do you need? I don't know, 5%, if that. Right? And then as things go on, you need more confidence. And if you want a search warrant, you need more. And as things go on, you need more and more and more until you ultimately get through the process to get to your ultimate stage. So the question at this stage of proceedings is, does the government have enough to be where they need to be right now? The answer in my view is yes. The government has enough to be where they need to be right now. Do we have 25, 30% confidence that Trump is in violation of the law? Sure, no problem. We've got a prima facie case all day long, right? We've got documents that are marked classified. We've got governmental documents that he doesn't appear to have authorization to. Do we have 25% confidence? Sure, no problem. Do we have probable cause? Well, we don't know, and I don't know enough to know for sure, because I don't know why the government still thinks he has documents. And just because they found them doesn't mean that they had probable cause, because you can't go fishing. Right? Just because you found the thing you were searching for doesn't mean you had probable cause to search. And so I don't want to make that mistake. Right? Just because we found the thing we were searching for does not mean we had probable cause to search. Right? You can't go fishing. Now, was the government fishing? I don't know. I don't have enough information. But I'm going to assume at this point that they had probable cause, for lack of a better alternative. And but there's still a lot of baseball left to be played. We got all kinds of questions. If we're dealing with classified information, we have to deal with whether or not they are classified, whether he changed the classification status. We're dealing with governmental records, whether or not he was authorized, whether or not blah 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 blah. Like, there's a lot of baseball left to be played. So we're nowhere close to being able to answer the legal questions ultimately. But I'll give you 30%. I think we got that. You know. Okay, as the last claim for relief, plaintiff asked the court to order the government to return any items seized pursuant to search warrant that was not within the scope. In plaintiff's view, retaining such material would amount to a violation of the Fourth Amendment protection against wrongful search. Well, no, but okay. Although plaintiff does not specify what material he contends was seized in excess of the warrant, certain personal effects were commingled with classified material in the seized evidence, and they remain in the custody of the United States because of their evidentiary value. Personal effects without evidentiary value will be returned. Nonetheless, contrary to plaintiff's contention, personal effects in these circumstances are not subject to return under Criminal Rule 41 for four independent reasons. First, the search warrant authorizing seizing and retaining items in boxes in which documents were stored. Evidence of commingled personal effects with documents bearing classification markings is relevant evidence. Well, it goes to perhaps the sloppy method in which they stored them, right? The fact that there's personal stuff there shows sloppy management and sloppy management of potentially classified information. So there seems to be some initial signs of relevance there, right? Whether or not they're relevant, we don't know, but on our standard that we're trying to solve right now, sure. Malcolm Witham says, Canada, $5. Would Trump have been required to hand over documents he believed to have been declassified? Perhaps that's why those documents weren't handed over. Well, he would have to say, like, that was the case, and he didn't. Right? He would have to, like, make that clear, and he didn't. Because the government has no way to know. That's the problem, right? The problem is, right, if you're viewing this from the government's, if you're viewing this from the court standpoint, right? If you're viewing this from the court standpoint, like, okay, the government wants a search warrant for the classified materials, right? So if Trump doesn't say, well, I'm not turning them over because they're not classified, because I declassified them, like, if Trump doesn't say that, then how is the government supposed to know, right? And the government can't know. What the government might be able to know based on, sources, eyewitnesses, a mole, whatever, I don't know. But what they might be able to know is that there are documents marked classified. If they're marked classified, then your assumption is they're classified. That's correct. they are being marked classified as prima facie evidence of classification. It's not determinative, it's prima facie. Right? But if Trump doesn't say, well, hey, they're not declassified, then all the government would know is, well, they're marked. And so you're there. And so Trump not providing that information can't be a factor in the equation, right? If Trump had said, they're declassified or something, and provide some evidence of that, and affidavits and declarations and stuff like that, they might very well have to provide that to the judge as part of the search warrant analysis. But, it doesn't quite, In a crazy world, if you're Trump's lawyers, how would you defend them? Yeah, so many different ways. I mean, I don't have enough information to know the answer to that question, right? I don't have enough information to know the answer. Like, how would I defend him right now? I'd be trying to do kind of what they were doing. I'd hopefully be doing it earlier. Because I don't have enough information. And I don't want to commit to a position as a defense lawyer before the government does. Like, one of the benefits of being the defense is you get to go second. All right, the government has to go first. So, like, how would I defend him? To some degree, I don't know. Because the government has yet to fully clarify its position. And I'm not going to commit to a position before the Department of Justice does. Right? I'm gonna make the Department of Justice lock itself in as best I can before I even contemplate what I'm going to do. Right? I want them to commit their moves on the board before I even think about committing my moves on the board. So to some degree, I don't know. But what I'm thinking about in terms of possibilities is like, well, what I'd want to know is what I'd want to do, and I want to do research on, is the degree to which, first of all, other presidents have taken materials out of the White House and say, well, including classified materials, to show that this is not abnormal behavior, or how other presidents have handled requests like this. I'd want to do research and see how materials with other presidents have been handled. I'd want to know more about why the affidavit from the custodian seems to be so out of sync with what the government is saying. Like, what's going on there? So I need to interview some of these people. But down the line, I'm thinking, well, Trump had the ability to declassify, although that doesn't seem to be the issue at the moment. Classification doesn't seem to be the issue. Government records, I'd be thinking, okay, does the government are these originals with no copies? If these are originals with no copies, then, we made a mistake, oops, our bad, no intent, to go the intent requirement. That President Trump himself, Trump himself didn't go and look. He sent someone to look, and they were sloppy in their job. And so there's no intent from Trump. I could go attack the intent element. That's promising. Trump probably didn't pack up his own office, or any part of it. So that's how the records get there in the first place. The movers just moved them. And he didn't know they were there because he didn't go look, probably. Probably doesn't spend a lot of time in his own storage room, I would guess. He trusted other people to manage that, and those people fell through, so lack of intent. Those are some of the ideas that come to my head. Trutal gives 10 Canadian dollars. Thank you very much. I appreciate it. Okay, let's see, where were we? Second, even if personal effects were outside the scope of the search warrant, their seizure and retention would not violate the Fourth Amendment because they're commingled with documents. Yeah, the initial seizure would not be a problem. Third, even if personal effects were seized in excess of the warrant, which plaintiff has not established, 41G does not require their return because the rule was amended in 1989 to recognize the United States may retain evidence collected while executing a warrant in good faith. As the advisory committee explained in connection with the 1989 amendment of the rule, Supreme Court precedent permits evidence seized in violation of the Fourth Amendment, but in good faith, pursuant to warrant, to be used even against an aggrieved person of a constitutional violation. And Rule 41E is not intended to deny the United States the use of evidence permitted by the Fourth Amendment and federal statutes. Yeah, basically, if the government has the right to search, then they can search things and take things, and if they seize them in good faith, then you're probably screwed. That's about right. The decoupling of the criminal rule from the Fourth Amendment also explains why a motion to return property provides no forum to litigate the scope of a search warrant. Failure to comply with search warrant or the Fourth Amendment is neither necessary nor sufficient to prove entitlement of return to property. Fourth, and independent of these reasons, the former president could obtain the return of personal effects under the rule only if he satisfies a four-part test. That decision established four factors that inform whether courts should entertain a Rule 41 motion for return of property before initiation of criminal proceedings. Whether the movement shows the government agents displayed a callous disregard for rights, which probably not. Whether the movement has an interest in and need for the materials, probably not. Whether he be irreparably injured by denial of the property, probably not. And whether he has adequate remedy at law for grievance, which he does in form of suppression hearings and the rest of it. So that doesn't sound really promising in terms of that four-part standard. Although the former president may have a property interest in his personal effects, he cannot demonstrate callous disregard of the Fourth Amendment, considering the patient exhaustion of less intrusive methods to obtain return of documents with classification markings, and the FBI agent's scrupulous adherence to terms of the search warrant, which permitted them to seize entire containers of boxes in which documents with markings were stored, as well as other containers that were stored collectively. Moreover, the former president has not established irreparable injury. I do like how they pat themselves on the back for their own scrupulous adherence, which, okay. To the extent plaintiff seeks a preliminary injunction, which, it didn't really say preliminary injunction, which is why you're writing this. To the extent you're seeking a preliminary injunction, the government, such relief is unwarranted. A party seeking preliminary injunction, we know the standard, for reasons set before the former president has not established a likelihood of success. As the second condition, the former president has failed to establish he suffered any injury. That seems right. Like, why does he need these documents in particular? What is his interest in them? Why is he harmed by not having them? That seems a little bit iffy. Second, even if the review of these materials by personnel within the executive branch constituted an injury to the former president, that injury is already complete. There's that. You asked for it a little late, so there's that. As described above, personnel within the case team have already reviewed all the seized material except those withheld pursuant to the filter protocol. Moreover, as the government notified the court yesterday, DOJ and Office of the Director of National Intelligence are currently facilitating a classification review of these materials, and the Office of the Director of the National Intelligence is leading an intelligence community assessment of potential risk to national security that would result from disclosure of these materials. Any possible injury then is most incremental and theoretical. I mean, they have a point, to be sure. Finally, the former president filed this motion 2 weeks after the search occurred and only just affected service of the United States. Yep, that's a problem. The very idea of a preliminary injunction is premised on the need for speedy and urgent action. That is why district courts have found that parties' failure to act with speed and urgency necessarily undermines a finding of harm. They're not wrong, man. They're not wrong. Although courts have generally considered delays of a few months or more as a factor against granting relief, a delay of 2 weeks in this is particularly significant. Typically, parties who seek the appointment of a special master following execution of a search warrant make such requests immediately. They sure do. They're not wrong. For example, after FBI agents executed search warrants in 2018 at various properties belonging to Michael Cohen, who of course was an attorney, Cohen's counsel sent a letter to that same day to the United States Attorney's Office requesting appointment of a special master. Yeah. After that request was denied, Cohen filed a motion for temporary restraining order. Then President Trump himself moved to intervene in the proceedings on the 15th, just 6 days after the search. So within 2 days of the search, Cohen was moving for the special master. Yeah. The need for promptness when a party seeks appointment of a special master is obvious. The government may begin reviewing the materials as soon as they're seized, and a delay of even 2 weeks may well mean, as it does here, the government's reviewed all the seized material. A former president's delay militates against finding of harm. Yeah, it's a little late. You can even go further and basically be like, your request is moot, which it kind of is. Your request is moot. You want a special master to review materials before I do, but I've reviewed them, so yeah. Not so much. Not so much with any of that. Let's see, where was I? As a third requisite for injunctive relief, the threat and injury to the movement is far outweighed by damage the proposed injunction may cause the government. DOJ is in the midst of an ongoing criminal investigation pursuant to potential violations of the Espionage Act, as well as obstruction of justice and unlawful concealment or removal of governmental records. Yeah, they're definitely doing those things, to be sure. The intelligence community is also reviewing seized documents to assess potential risk to national security that would result if the materials are disclosed while they're unlawfully stored. Yeah, I don't think there was probably any exposure there, but the intelligence community can certainly think about it as hard as they want. An injunction barring any further review of the documents would therefore not only hinder an ongoing investigation, but also thwart entirely ongoing and sensitive review of risk to national security. All those things, to be sure. Okay, printer. Okay. Anyways, $4 super sticker from Cherry and Max. Thank you, Cherry. You've been very, very generous this entire time with the super chats, and I just want to say thank you. Because it's of people like you that make this channel possible. You know, as of July 2nd, as I've talked about, this channel is now my full-time gig. And I want to bring quality legal education to you. We do have a stream later tonight as well at 6 p.m. Eastern Time, so that's in 2.5 hours from now. We're going to be doing a stream relating to a idea I've had for new content for the channel. So the stream for tonight is tentatively titled "There Once Was a Person Named," and the idea is we're going to go through great cases of history that are not necessarily notable in terms of seizing public consciousness, right? So this is distinct from Trials of the Century, for example, because Trials of the Century, which Rob has been doing and doing extremely well, right, is all about cases that have seized the cultural zeitgeist, cases that got huge amounts of newspaper attention. And I'm going to be doing something similar in cases that perhaps less with the newspaper attention, but more of foundational cases or cases that were extremely important in the development of the law. And so I have tentatively titled this, "There Once Was a Person Named," which, you know, we may need work on the naming of it, but that's what I've tentatively titled it. And tonight at 6 o'clock is Gideon versus Wainwright. So we'll be talking about Gideon, who was a guy named Gideon, who said, "I have the right to an attorney." And the court said, "No, you didn't." And he decided to fight that, and that's what we're going to learn about today. So that's going to be really, really exciting. So I do appreciate everyone who contributes to this channel financially. And for those of you who are unable to contribute financially, I'm very, very happy that you're here, and you can contribute in other ways. You can contribute by hitting that like button. And you can also contribute by hitting the subscribe button. If the subscribe button is red, it is yearning for your click. It is feeling a deep-seated desire that is being expressed through its redness. So make sure to click it so it becomes a gray subscribe button and becomes satisfied. You can be the change we want to see in the world. Make sure to have that happen today. So let's go ahead and keep reading this. Yeah, the title may need work. We'll workshop it. In title may need work. We'll workshop it, but yeah. Okay, as described above, the government's privilege review team has already identified any materials potentially subject to attorney-client privilege, and the government's investigative team has already reviewed all the materials that were not segregated by the privilege review team. Appointment of a special master to review potential privilege claims in either category is therefore unnecessary. It would do little to nothing to protect any legitimate interest the plaintiff may have while impeding the government's ongoing criminal investigation, as well as the intelligence community review of potential risks to national security that may have resulted from improper storage of seized materials. In this potential posture, a special magistrate can be appointed without the parties' consent only to address pre-trial and post-trial matters that cannot be effectively and timely addressed by an available district judge or magistrate judge of the district. Reference by a master under Rule 53 is an exception, not the rule. It is unusual, although it's more common in privilege cases. The former president asserts that review by a special master is necessary because the records at issue here are presumptively subject to executive privilege. But even if the former president had actually asserted executive privilege with regard to any of the seized documents, which he has not, and even if he had statutory authority to do so, which is not established, such assertion would fall here because the case involves recovery and records of executive records by executive officials performing core executive functions. Yeah. The Supreme Court has made clear a former president may not successfully assert executive privilege against the very executive branch whose name the privilege is invoked. So apparently there is a Supreme Court case on this point, Nixon versus GSA. So that would speak to this question. We might have to cover that at some point in the future. And there might even be some extraordinary circumstances. Apologize. And even if there might be some extraordinary circumstance in which a former president could successfully assert executive privilege against the executive branch, this case would plainly not qualify. The seized materials, and in particular, any materials marked as classified, are essential to criminal investigations in the handling of the records, and the government is also reviewing those highly sensitive records to determine whether their handling creates risk to national security. Those vital executive branch needs far outweigh any limited burden on general interests served by executive privilege. Finally, appointment of special master in these circumstances will be inconsistent with basic principles of equity. Even if the former president had attempted to assert executive privilege, which he has not done, the assertion would not justify any restrictions on executive branch access to the documents. Executive privilege is inexorably rooted in separation of powers under the Constitution and derives from supremacy of the executive branch within its assigned area of responsibility. The privilege exists not for the benefit of the president as an individual, but for the benefit of the republic. Right? It's the distinction between the person and the office. Right? Executive privilege belongs to the executive, and Trump is not the executive. So how can he have executive privilege? Yeah. Consistent with privileges functioning of protecting executive branch as an institution, it may be invoked in appropriate cases to prevent sharing of materials outside the executive branch, for example with Congress, the courts, or the public. And then C for comparison, Trump versus Thompson, noting unresolved questions about whether and under what circumstances a former president can invoke the privilege to prevent such disclosure, in that case to Congress. Yet the former president cites no case, and the government is aware of none, in which executive privilege has been sufficiently invoked to prohibit the sharing of documents within the executive branch. That's the problem. That's the problem. The privilege belongs to the executive. Trump is not the executive, so he doesn't have the privilege. The executive does, which is not him. He was the president. He does not currently serve in the office of the president. The office of the president has the privilege, not him. Never him, personally, strictly speaking. For that matter, Biden doesn't have it personally, right? He only has it professionally. There is definitely a distinction. To the contrary, in what appears to be the only case in which such an assertion has ever been made, Nixon versus GSA. The Supreme Court rejected former President Nixon's assertion the statute requiring the General Services Administration to take custody of and review of records and documents created during his presidency violated either separation of powers or executive privilege. Addressing the separation of powers, the court emphasized that the administrator of the GSA is himself an official of the executive branch, and the GSA's career archivists are likewise executive branch employees. So not so much on separation of powers, it's the same thing. The court rejected the former president's invocation of privilege against the statutorily required review of the GSA, describing it as assertion of privilege against the very executive branch in whose name the privilege is invoked. It doesn't make sense. The court explained the relevant question was whether review by the executive branch officials within the GSA would impermissibly interfere with candid communications of views by presidential advisors, and held the question was readily resolved because the review in question was a very limited intrusion by personnel in the executive branch too sensitive to executive branch concerns. Additionally, in the framework formed by the Presidential Records Act and implementing regulations providing for assertions of privilege by the former president, including executive privilege. So apparently there are some regulations or statutes on point. So, okay, fair enough. Fine. Okay, the framework set forth for providing assertions of privilege by the former president, including executive privilege, is inapplicable here. First, the plaintiff did not convey the seized materials to the National Archives as required by the Presidential Records Act. So there might be a mechanism for the former president to claim privilege, which in this case, by the way, is not coming from the Constitution, right? In this case, it would be coming from statute. So that would be the nature of the privilege, right? So it would not be like, it wouldn't be a constitutionally derived privilege, as it would with the president. In this case, it would be a privilege provided for by statute and the regulations thereto, which are extending things to the former president who otherwise has no executive authority. So fine, if there's statutory authority, fine, but we're no longer looking at the Constitution, we're looking at the statute. Okie doke. As such, he cannot now maintain he has a statutory right to make privileged assertions pursuant to the law. Right. So while president, he can look outside the statute because the Constitution gives him authority. When he's no longer the president, the Constitution doesn't give him authority. So now he is bound by the statute, right? So this is an interesting, this shows you, I think in some ways, the differences between the president and the former president, right? When you're the president of the United States and the Constitution gives you all the executive authority, you can make arguments like, well, you know, the Atomic Energy Act may not say I can do it, but I say I can because the Constitution says I can, right? And that argument at least makes sense. Regardless of whether it's true or not, at least you can make the argument, right? The Atomic Energy Act may not say I can just unilaterally declassify, but I say I can because the Constitution gives me the authority. And Constitution beats statute, right? When you're the president, you can make that argument. When you're not the president, not so much. So it's like, well, either it's the statute or nothing for you, bozo. And if you didn't follow the statute, which gives you the privilege, if you don't follow it, you can't say, oh, I have authority from somewhere else. No. Doesn't really work, you know. In that case, it's the statute or nothing, buddy. So, yeah, no. Make your own coffee, as it were. You know, you don't have the AIDS you used to. Okay. These principles resolve the former president's request for a special master. As in Nixon versus GSA, which I'm definitely going to have to look up at some point, this case involves potential assertions of executive privilege by a former president against the executive branch in whose name the privilege is invoked. The case does not implicate any disclosure outside the executive branch, and review of records at issue is being conducted by personnel in the executive branch sensitive to the executive branch concern. Accordingly, even in a case where the records might be withheld from the public pursuant to a valid assertion of privilege, there's not a basis for withholding them from the executive branch itself. Yeah. In any event, even if there could be some extraordinary circumstance in which a former president could validly assert executive privilege against the executive branch, this case is not it. The records at issue in this case involve two core functions of the executive: investigation potential unlawful handling of records, including highly classified records, and assessing the resulting risks to national security. Access to the records is essential to performance of these functions, and vital executive branch interests far outweigh any burden on the institutional interest the privilege serves to protect, particularly whereas here the former president has not even attempted to establish particularized harm. In United States versus Nixon, the Supreme Court held that need for evidence in a criminal trial outweighed even a sitting president's assertion of executive privilege over presidential communications. The court explained that although the interest of preserving confidentiality is weighty indeed and entitled to great respect, assertion of privilege must also be considered in light of historic commitment to the rule of law. There is nowhere more profoundly manifest in our view than the twofold aim of criminal justice is that the guilt shall not escape or the innocent suffer. Ultimately, the court concluded the generalized assertion of privilege must yield to demonstrate specific need for evidence in a pending criminal trial. So that should be the guilty. So just as the guilt. Typo. Similar logic appears here. The records at issue were seized pursuant to search warrant, reflecting judicial finding and probable cause to believe they constitute evidence of violations of statutes specifically governing the handling of governmental records in general and national defense information in particular. The executive branch has a demonstrated specific need for the records at issue because the records, and particularly any record marked as classified, are central. Indeed, they're the very subject of relevant statutes. And even more so than United States versus Nixon, there's little risk that possible review in the highly unusual circumstances presented here would materially chill communication by future presidential advisors. That's probably true in terms of the scope of the thing. To the contrary, the executive branch efforts here are designed to ensure the confidentiality and proper treatment of sensitive presidential records that are improperly stored, a process that should enhance rather than undermine future presidential communication. The executive branch's review also serves another compelling interest that was not at issue at Nixon. The records at issue include sensitive and highly classified documents. As the government has explained, the intelligence community, under the supervision of the Director of National Intelligence, is conducting a classification review of those documents and assessment of potential risks to national security that could result from disclosure. The additional vital purpose provides yet further reason to conclude the executive branch's interest in securing and reviewing these materials at issue outweigh any limited burden on confidentiality of presidential communications, and thus privilege would be overcome even if validly asserted. This court should be particularly reluctant to order disclosure of highly classified materials to a special master absent strong showing that such a step is necessary. Yeah, I mean, they ultimately might have to be revealed at trial, which is one of the things that the government has to balance when it's considering whether or not to bring these prosecutions, right? It's like you might have to disclose that to the jury, which then can disclose it to the world. So one of the reasons that you might not bring a prosecution you might otherwise bring is because you have to disclose the very thing that you're trying to keep secret in the first place. So there's definitely some challenges that are present there. The former president sought to invoke this court's equitable jurisdiction, but appointment of a special master to review seized materials for claims of executive privilege would be fundamentally inequitable. First, to the extent the former president's arguments rest on a claim, he's been deprived of rights under the Presidential Records Act to assert potential claims. The former president forfeited the ability to rely on the Presidential Records Act by failing to provide the records to the National Archives as the law requires. Had the seized records been returned to the National Archives upon the former president's departure from office or during the money months afterwards in which NARA sought return of the missing records, plaintiff could at least tender a claim of executive privilege to the archivist with regards to a material sought by the Department of Justice. Indeed, this is precisely what occurred when Department of Justice sought access to 15 boxes that were returned to NARA. As described above, the government resorted to a search warrant only after the former president failed to return missing records as requested by NARA, and then as required by a grand jury subpoena. The government seizure of records through the use of a search warrant is the direct result of the president's own conduct, and this inequitable conduct makes equitable relief inappropriate. I mean, that tends to be true. I tend to agree with that. I mean, the thing that's ultimately like killing this entire analysis for me is the time. Like, that's the problem. Like, the damage is already done. Everything else is just bonus. But then again, I guess to some degree, you don't necessarily know what a judge is going to care about and what they're not going to care about. So it goes to show like how different judges think about different things. Like for me, I was sold long ago because I was sold on the timing issue. It's like it's just too late. The damage is done. There's nothing for a special master to do. So, but a different judge might care about a different issue. So you want to make all the arguments, or at least all the ones that make sense, because you never know what a judge might focus on and what they might not. You want to give a judge many reasons to rule in your favor, I suppose is a good way of putting it. Second, for reasons described above, the government has an urgent interest to continue the review of these materials, both for purposes of criminal investigation and to assess potential security risks caused by improper storage of classified records. Appointment of a special master would undeniably delay both processes, including because the special master would likely need to obtain security clearance and specific authorization from relevant entities within the intelligence community to review particularly sensitive materials. Third, appointment of a special master for purposes of reviewing executive privilege claims is not necessary to protect any personal rights belonging to the former president. Unlike possible assertions of attorney-client privilege by the former president with respect to his personal counsel, which is a personal right that belongs to the client, executive privilege exists not for the benefit of the president as an individual, but for the benefit of the Republic. That's right, it belongs to the office of the president. In any event, as described above, the investigative team has already reviewed the materials. Restricting further review, including by the Intelligence Committee, would therefore do little to protect his rights. The appointment of a special master is not necessary to adjudicate potential attorney-client privilege issues. It's well established that filter teams, also called taint teams, are routinely employed for privilege review. Tellingly, cases relied upon by the former president that have employed special masters rather than filter teams invariably involve the search of law offices. Yeah, I don't know if it's invariable or not, but it's definitely the most common context, right? If you're searching a law office, there's a lot of people with a lot of potential privilege issues in play. So that isn't just one person's privilege, that's a lot of people's privilege. And so, yeah, the concerns there are more manifest. The former president analogizes searches of law office to the present search by claiming that there are contexts involving similar matters of privilege. Looking at the cases he cites, however, and the reasons why special masters have been appointed when law offices have been searched, it becomes clear the searches of law offices and the instant search do not all involve similar privilege concerns. I mean, yeah, that's true. It's at best one person's privilege versus dozens or hundreds of people's privileges. It's very distinct scenarios. The cases cited by the former president involve thorny issues presented by search of law firms. Courts have cited complexities posed when these materials are seized from attorneys involving multiple clients. Yeah, each of those people has independent privileges. Yeah. Electronically seized materials containing all of Lawyer A's emails correspondence, including email correspondence related to Client A and numerous other law firm clients. More specifically, Lawyer A's seized inbox contains 37,000 emails, of which 62 were from Client A or contain Client A's summaries. And how about the rest of them, right? The judge may have well rejected the filter team and its protocol if the judge had known that 99.8% of 52,000 seized emails were not from Client A, were not sent to Client A, and did not mention Client A. That's a lot of people's potential privilege. The attorney-client privilege issues in this case present none of these complexities associated with the search of a law firm. This is not the case where the U.S. Attorney's Office has seized materials related to multiple clients who may also be under investigation by the same office. Moreover, as noted above, the volume of documents is small and the government's folder team has already completed review. It is prepared to follow the procedures set forth in the warrant, including and introducing a special master would only result in delay. Yeah, I think that's, yeah. For the above reasons, the court should not appoint a special master. If the court decides to do so, which is not a wholly unreasonable thing because the judge has indicated some interest in it, although I'd be much less interested at this point if I were the judge, but that's just me. The government proposes the following conditions. First, the court should direct the parties to confer and submit a joint list of proposed candidates. Second, the special master should be required to submit an affidavit concerning any potential biases for disqualification. Third, the court should specify the following duties and impose the following limitations. The special master's duties should be limited to assessing plaintiff's claims of attorney-client privilege over potentially privileged documents identified by the privilege review team. For reasons articulated above, there's no precedent or basis for appointing a special master to review documents for executive privilege. That makes sense because it's not his privilege, right? Yeah. And barring current executive branch law enforcement officials or officers from continuing access, including to assess national security. If a special master must be appointed to review classified materials, in order to avoid unnecessary delay, the special master should already possess top secret SCI clearance. I mean, yeah, no duh, right? If we're going to do this, let's appoint someone who already has, top level clearances to make this less a problem. The special master should be allowed to communicate with ex parte with the court or either party to facilitate review, although all final decisions must be provided to both parties. That makes sense. Any documents that reflect special master's rulings in court order, privilege logs, or other records should be preserved and filed under seal, but made available to both parties. The parties should have 10 days to review. The court should impose a deadline. These are not unreasonable procedures, but at this point, if I'm the judge, I'm saying no. The time issue is the big one. It just doesn't make sense. And they've already reviewed it, so it's moot. So, all that stuff. Certificate of service from the Department of Justice. And now we've got some attachments. So here we are in some attachments that show some of the processes that are apparently undergoing. So this is a letter to the chairwoman of Oversight and Reform of the U.S. House of Representatives. And we can skip this, at least a part, because that just shows efforts that we've done in the past, which doesn't really speak to the issue I care about, which is what is our evidence for believing the documents are still there, right? Like, we had problems in the past is one thing. Why do we still think there's documents there? And that's the thing that I care more about. So we'll skip that for now. Attachment B. Some more correspondence about the difficulties of documents, blah, 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 blah. Fine. Attachment C. Here is a subpoena to testify before the grand jury to the custodian of records, which is requesting any and all documents. Show that we're trying to obtain this in May. Any and all documents in the control of Trump or the office of Trump bearing classification markings, including every classification marking known to man. And then we found more stuff, which maybe shows that we're not doing so great on the compliance with that. Here's a declaration of service. That's fine. Attachment D. Grand jury subpoena to Evan Cochran. The custodian may comply with subpoena by providing responsive documents. The custodian would also provide a sworn certificate. Apparently the custodian's not very good at their job because we found all kinds of stuff. Attachment E. Certification from the custodian of records. I've been designated to serve as custodian of records for the purposes of testimony and documents of the subject of the subpoena we saw earlier. I understand that the certification is being made to comply with subpoena in lieu of personal testimony. Based on information and belief, I've conducted a diligent search. Did you, though? The search was conducted after Fisa's subpoena in order to locate any documents. They've been provided with no copies. Yeah, we have some questions about your ability to certify all that at this point. whether or not you were telling the truth or not, or you knew you were lying, which is perjury. Attachment F. And here are some things we found, which, again, is not illegal. I mean, certain documents have been blacked out and whited out, as you can see in the photographs, because apparently those portions were, so certain documents without covers have had their white part, have had documents exposed. And apparently this is the controversy now, because, oh my God, I can see the cover sheet. I can see the cover sheet. I can see the cover sheet where it says secret SCI or top secret SCI. Oh my God, I can see the cover sheet. Yeah, that's not a problem. So, yeah, that's fine. So there was some stuff there that's going on. So what is the end conclusion what is the end conclusion I can give you at this point? Well, the end conclusion I can give you at this point is I think the Department of Justice is right because the issue is moot because of the time issues. Also because he never could invoke the privilege in the first place because it was never his. What limited attorney-client privilege material there is has been already reviewed and filtered out, and we're going through the standard process, and there's no point. So yeah, that's what I kind of think about this. So if I'm the judge in this, I'm inclined to deny the request at this point. If I was inclined before, I'm inclined to deny now. Because I'm like, yeah, that's pretty good arguments. Like, yeah. So that's kind of how I think about it. $5 from Molly Dolly. If charging Hillary would have been political, going after Trump wouldn't? You've alluded to Trump not having nefarious reasons for having the documents. Well, I don't know whether or not he has nefarious reasons or not. I don't have enough information. Although I did say that he's a man of pure id, which kind of would preclude nefariousness, I suppose, to some degree. But is going after Trump political? Unavoidably. Right? The only question is, like, what is the balance of the law versus the balance of the politics? And I'm not at all convinced at this point that the balance is more legal than political. Although the Department of Justice is heading in that direction, to their credit. But the politics here are obvious. Right? The politics here are obvious. And I think also that President Trump's search warrant, I think also President Trump's lawsuit made a point, and a valid point, of pointing out that there have been elements within the Department of Justice and within the FBI that have just blatantly lied against him and done things to him that are illegal, including, for example, lying to the Fisa court to get a Fisa warrant so that we could spy on his campaign illegally with the lies. That's a problem. And also, the Steele dossier and its bases, that was a problem. And so, like, I think the problem here is that up to this point, the FBI's credibility when it comes to Trump is, I think, reasonably suspect. I think people who are questioning and doubting the FBI, I think the FBI has done, and the Department of Justice, has done a lot to earn that consternation. I think, I mean, how many times, how many times in the last, say, 5 years have we heard from the news or from a politician or from a member of Congress or whomever? How many times in the last 5 years have we heard some version of, this is it, this is the one, this is where President Trump goes down, this is where candidate Trump goes down, this is the day, man, that we're going to get him. And how many times, like, this is it, and how many pundits have said, this is the one? How many times, right? And so, it's the boy who cried wolf. It's the boy who cried wolf, man. That's the problem. Among other issues, man. It's just the boy who cried wolf. It's like, how many times, man? It's been a couple times. And how many of them turned out to be pretty shit? Most of them turned out to be pretty shit. Right? So I think people who are like, I have some skepticism with the FBI and the Department of Justice when it comes to Trump. A little bit of warranted. A little bit of warranted. Now, personally, I think the decision not to charge Hillary Clinton was defensible. Whether or not it was the right decision or not is, open to debate or not, but I think it makes sense from first principles. Whether or not Comey was doing the right thing or not, or whether or not Comey could have done that and a whole nother thing. It's like, there's a lot of and you can disagree with the proposition, right? Because I think you can make out the prima facie case against Clinton. You can make out the prima facie case against Hillary Clinton. But again, I think for similar reasons, I didn't think there was a lot of there. There were some things, but it just wasn't very much in the grand scheme, at least that you could prove. It wasn't very much that you could prove. And so the decision not to prosecute made sense, at least to me. I mean, the way that Comey went about it left a lot to be desired, but it's like a little, if you're questioning the FBI and you're questioning the Department of Justice and you're questioning their motivations, when you have people like Peter Strzok, who's like, yeah, we're gonna do whatever it takes to prevent Trump from getting elected, and we know that Trump is going to run for office again, and he's the front runner for the Republican Party, and I think the front runner to win at this point. Now, personally, I kind of wish Ron DeSantis or Nikki Haley would win, but I don't think my wishes are going to carry the day. But the politics of this whole thing are unavoidable. And if it turns out to be, piddly, I don't think people are going to accept it, even if it's legitimate. I think it's one of those things that, you have to, it's one of those statements, you're going to bring down big game, you better get it with your first shot. And unfortunately, the FBI has long since exhausted its, first shot. Yeah, this, the walls are closing in. How many times, man? How many times? So, yeah. Yeah, there is a wolf in that story at the end. Yeah. I'm not saying that there's not a wolf. I'm saying that everyone doubting the wolf is right to doubt it. And there might very well be a wolf, but the FBI's credibility is kind of shot a little bit. Which is one of the reasons, I haven't said that I don't think Trump hasn't necessarily done anything wrong, but the DOJ's credibility is a little thin. So we'll see. When you take a shot at the king, you better not miss. Basically, yeah. That's the problem. That's the problem. Alpha photographer, if you come for the king, better not miss. Basically exactly that. That is the problem, for sure. So, it is thin. It's a little thin right now. The Department of Justice has its prima facie case, but it's thin. And it feels unsatisfying in a lot of ways, And again, not for nothing, right? And it doesn't necessarily impact the legal analysis, but I'll just simply point out that people, including Democrats, have for years pointed out the problems of overclassification, right? So the degree to which it should matter or not, I'll leave up to your judgment, right? But I will simply note that simply because it is marked TS-SCI doesn't mean it should have been marked top secret SCI. It is quite possible, and that some of these documents were overclassified in the first instance. The degree to which that should or should not matter, in sort of a legal analysis, but still, I'll just simply note that government overclassification is a bit of a known problem. Is there a FISA-like court for criminal cases with top secret evidence? No. Yeah, that's the FISA court. The FISA court, for all of its problems, right? All the FISA court can do, which is not nothing, but all the FISA court can do is issue warrants. That's all the FISA court does, is issue warrants. All they do is decide whether or not to issue warrants against U.S. citizens or targets in the United States as it relates to foreign intelligence. Now, those search warrants, like, if the Department of Justice wants to use that evidence in court, right, they have to expose the evidence. You have to expose it to a jury. And so that's one of the problems, right? You have to prove it to a jury. So, one of the reasons the Department of Justice may not prosecute even in where they can is because of exactly this problem. So yeah, there's no secret trials because it's against the Constitution, right? You can't really have that. So you can't keep it secret from the jury. That's for damn sure, right? So yeah, and you can't just, it has to be a jury of ordinary citizens. It can't just be like, oh, we're going to find a jury of ordinary citizens that also happen to have secret clearances. So you have to make it be a generally available jury. So you have to make a decision as the U.S. government whether or not you want to expose that or not. So Hamilton says this is not about low classification. There's a huge difference between classified and top secret SCI. This is about national security at the highest level, which keeps everyone safe. I will simply argue respectfully, Hamilton, in my humble opinion, it has been demonstrated, at least in my view, it has been demonstrated by declassification of materials that used to be top secret. It has been demonstrated to my satisfaction that from time to time, material that was classified top secret, at least in my humble opinion, should not have been classified top secret. So I will simply say that top secret SCI is not necessarily a guaranteed indication, at least in my humble opinion, that classification status is warranted. But that's my humble opinion. There should absolutely be a difference between confidential, secret, and top secret. There should be a distinction. The degree to which there is a distinction, I think, is less certain, at least in my opinion. There are no ordinary citizens in D.C. First of all, there's plenty of ordinary citizens in D.C. Second of all, the location of the crime is apparently Mar-a-Lago. Remember? That's the place where the documents are. Because President Trump moved to Mar-a-Lago on, what was it, January 18th or something like that? He moved out of the White House and moved to Mar-a-Lago on like the 18th or the 19th, while he was still president. So the crime isn't in D.C. The crime's in Florida. So first of all, there are plenty of ordinary citizens in D.C. Second of all, I don't think this is D.C. I think this is Florida. Susie Q42 says, you always make me think about my own position on things. That's why I really enjoy your channel. Thanks. You're welcome, right? And I want you to think. I want you to think about things. And like, yeah, there's potentially issues here. And there's a lot of game left to be played. But if you're looking at this, that's prima facie. I mean, it's literally on its face. Literally on its face. It says secret. Literally on its face. It says top secret. I mean, it's literally there. I'm looking right at it. Right? So, if you're trying to get to your, it appears to be standard, which is kind of what you need for a search warrant. You're there. Surely it appears to be. But then again, of course, the cover itself is not protected. So, I mean, not to put too fine a point on it, but if you really wanted to, because the cover itself is not secret, you could, if you were so inclined, you could print out the cover yourself. As just an ordinary citizen, you could print it out at home, and you could put it on documents, and chuckle to yourself softly, So I mean, I'm not sure so necessarily sure that's a wise course of action, but it is. It is. There's nothing stopping you from doing. I'm not sure I would necessarily do that because if you do that and it comes to the U.S. government's attention, you're going to have some people raiding your house, and then you can't be like, oh, but it was all a joke. That's going to be a problem. So I'm not necessarily sure I'd go around doing that. I'm just, it's available. Yeah, exactly. Yeah. The cover sheets themselves are not classified. This is absolutely correct. The cover sheets themselves are not classified. Correct. The cover sheet simply says that what's inside is classified. That's prima facie. Yes, you can look at the cover that says top secret. You have to be able to look at the cover because otherwise that wouldn't make any sense, right? This will go to the Supreme Court? Maybe. We're a lot of steps away from there, my friend. Well, possible. Possible. Cavalier says, why would the government care about me having my own personal classified top secret documents? They wouldn't. The problem is, how's the government supposed to know the difference? This is what I was trying to tell you, right? So there's nothing illegal about, because the cover that sells is not classified. So you can get a better quality picture of that cover. You can get a better quality picture of that cover, and you could, print them out. You could make them look right. You could make them look nice, and you could put them on documents. So why would the government care about them being your own personal documents? They wouldn't. The problem is, of course, if you put that cover on it, what does it look like it is? What does it look like it is? So the government knows that, you're doing it as a funny joke, then, great. But what does it look like it is? What it looks like it is that you have possession of classified, top secret, classified materials. That's what it appears to be. And the government's going to care about that a lot more. Right? So why would the government care? Well, because what does it look like it is? That's the problem, right? That's the problem. Susie Q becomes a member. Thank you very much for hitting the member. And prima facie is the correct spelling. That's correct. That's right. On its face. That's the right one. Can I do a mini recap? I can try. So the Department of Justice filed a response in request for Donald Trump asking for the appointment of a special master. A special master is a neutral referee. They're like a judge. And they're appointed by a judge as a help. They're basically an assistant judge appointed by the judge. It can be anybody. It's usually someone with particular expertise, a special set of skills, right, to help the judge. So Trump wanted a special master to review the documents for privilege. And the response from the Department of Justice, among other things, was it's a little late in the day because we already reviewed everything. So, yeah. But that's basically the summary. Yeah. And, yeah. If you read stuff put out by the intelligence community, yeah, overclassification is a bit of a meme. It's not unfair. There's been a lot of complaints over the years about overclassification, and not unjustly so. So how much that should impact the analysis is questionable, but what is the difference between an LLC and other corporations? That's complicated. The principal difference is in the nature of the ownership of the corporation. LLCs are more tightly owned is usually the distinction. Corporations are big things. LLCs are smaller. Is the easiest one. There's also some differences on the taxes. There's also differences in terms of the differences between the separation between the individual and the corporate form. If you're asking why I formed an LLC versus a corporation, it's like, well, because it's a lot more. I don't need I don't need a the reason I need a corporation is if I need to do lots of fancy things, and I don't need to do fancy things. I'm probably not going to be issuing stock like on a stock market and doing things like that. So I don't really need the full fat corporate form. LLC will be fine. LLCs are typically in private. I don't know if there's any LLCs on a stock market exchange, but yeah, they're smaller, they're more nimble, they're a lot. Yeah, they're small. Yeah, I'm not going to be issuing a lot of stock, so probably okay. Yeah, Uncivil Law LLC is now in business, as the description of the channel notes. So that's exciting and fun. Primer says, now explain S corps, pass-through income, limited partnership, and how real property rights are varied and transferred based on partnership type. That's okay. I'm going to leave that as an exercise to the reader. Not for at least reasons. I don't really understand what an S corp is yet. I'm working on it. I'll get back to you. But you can be both an S corp and an LLC at the same time. I've yet to figure out whether Uncivil Law LLC is also an S corp or not. I still have some time to figure that out, so I'll get back to you on that one. LLCs cannot issue shares of stock. I don't know if that's strictly speaking 100% true, but if I wanted to try to do it beyond any sort of distribution of any sort of size, yeah, it would be a problem. If the former president were convicted of a crime, where would they sentence him? Would Secret Service be obligated to protect him in prison? Sure. Yeah, I think so. And where would they serve him? I don't know. That's a whole other set of problems. You lose your Secret Service on conviction? You might be right. I'd have to double check the relevant statutes. You might be right. I know you lose your Secret Service if you are impeached and convicted by the Senate. I know you lose your Secret Service protection if you're convicted by the Senate. I do not know if you lose your Secret Service protection if you're convicted by the judicial branch. I do not know the answer to that one. Donna says, I can't issue stock because it evades the fundamental legal structure of being a limited liability corp. Okay, well, you guys may know more about it than me. I wasn't really planning on issuing any stock at all. So, because it's me. So, there's no stock in Uncivil Law. Although that'd be hilarious. That'd be hilarious if I convert into a full fat corporation at some point just so I can issue stock in Uncivil Law. In Uncivil Law, you guys can literally own a piece of me. Maybe in the future. That would be one hell of a Patreon tier. Can you imagine? Literally own a piece of Uncivil Law? Wow. That'd be good. We could have hostile takeovers and everything, man. Oof. Rough. Maybe sometime in the future. On that one. I should issue stock. If you bought out, you can no longer use your name. That's true. But that's one of the reasons, by the way, that the channel is not named after me personally. See, because I didn't make that mistake because I'm not a complete idiot. Right? So I can still use my personal name, right? So if I sell the business, Uncivil Law, right? I couldn't operate under that name, but I could operate under a different name that would be still distinct from my name. So, just change your name to horse. Nice callback. Doesn't a corporation need to publish financial records? Again, this is well beyond me. If you have stock and you're regulated, I think so. I don't know the full details about that. I don't know. I'll get back to you. If I make my own cryptocurrency, I think my legal exposure is going to go up rapidly. I'm not sure that that's a good idea. Please do not go with Kurt's Corner. All right, I'm going to wrap this up because I have to be on stream in an hour and a half. And I need a break and I need to do some prep. So I'm going to take a break. But be back in an hour and a half and we'll have some more stream. It'll be fun. So we'll see how it goes. Until then, my friends, remember to do all the YouTubey things. Like, comment, subscribe. Until there then, I hope all is well. Cheers, my friends. And goodbye.